Your satisfaction is our commitment. That's the catchphrase for Prime Insurance. Kelious, please come forward. Speaking like big brother now. Kelious Mlenga, please come to the chat room. All right, so once Kelious Mlenga is setting up, please, that was Prime Insurance telling us what they do and what they don't do. Please, I'm inviting to the platform Mr. Kelious Mlenga to do a presentation on the 60-40 law. So please pay attention, because this is very important as we go into the field to start working. The law is there already. Thank you very much. Over to you, Kelious.
All right, thank you very much. It's quite a challenge for me to present at this time, especially when the presenters before me have eloquently addressed the issues, and moreover, I'm standing before between now and lunch, which is a very important activity. So I'll try as much as possible to make this presentation short, though it wasn't my intention to do so. I wanted to go as detailed as possible. Can you help us on this? I think I pressed the wrong button. So all protocols observed, not waste too much time. I'll present two legal instruments. The two instruments are the ones which the Director General of PBTA introduced. The regulations on the 60-40, as well as an order on promotion of participation of micro, small, and medium enterprises in public procurement. First of all, before I start, I need to put on record the underlying assumptions on this law. These are just drafts as we're talking, they are not yet in force. Secondly, these are not new laws. We are only attempting to expound what is already in the law. For example, the 60-40 requirement was passed in 2017 by Parliament. The section 4410 of the Public Procurement and Disposal of Public Assets Act. The MSME order is an expansion to section 36.2 of the same act. So I would like to put it on record that we are not introducing new things. So I need to lay the background about the act. I think I've talked about it. But one of the salient features which the act has introduced is a requirement that 60% preference be given to indigenous black Malawians in NCB, National Competitive Bidding method kind of procurement. Another aspect is on introduction of margin preferences, and such as reservations and set-asides for local MSMEs. So what is the justification for these two laws? It's a form of affirmative action. Affirmative action is sort of positive discrimination. The law allows when there is a disparity in which people or rights holders are enjoying their rights, to put measures to bridge the gap so that we should all put at the same level. So the current affairs is that, according to the budget statement, 87% of public procurement is going to non-indigenous black Malawians. So only 13%, less than 13% is the one that is awarded to indigenous black Malawians. So it is felt that when you put this measure, then the measure will try to bridge the gap. What are the constitutional justification? Under section 20, discrimination is prohibited, but the same section in subsection 2 allows putting measures that are designed to address inequalities that are there in the society. So based on this, we are within the framework of the equality provision. What about from international perspective? The United Nations do also prohibit discrimination in terms of whatever ground. But the relevant instrument here that I can talk about is the UN Convention on Elimination of Racial Discrimination, which I'll abbreviate as the SED. 1965, Article 1, Sub-Article 4 allows that special measures can be taken for the purpose of securing adequate advancement of certain racial ethnic groups in order to ensure equal enjoyment of human rights and fundamental freedoms. This is also echoed in the General Comment by the UN, General Comment number 24, which has specifically mentioned that states should design measures to ensure that there is enjoyment or sharing of territorial or benefits or exploits. In this case, we are giving an example of procurement, that all of us should all be inclusive. Under the WTO regime, it's also allowed. WTO is World Trade Organization. This is the international body that is responsible for regulating trade. And under the framework, it's also allowed for states to put measures to their infant industries so that they should be put at a more competitive position to be able to compete in trade. This can be in form of anti-dumping duties, countervailing measures, and safeguard measures. Worldwide, the US also has affirmative action. As early as 1978, the Supreme Court of US, in that case of Regents versus University of California, Regents of University of California versus Bar. UK, they term it positive action. In Canada, they have what we call procurement strategy for Aboriginal business, just to favor a certain, the indigenous. In RISA, Republic of South Africa, they have what we call Broad-Based Economic Empowerment Act and preferential procurement regulations that were enacted in 2017. And also preferential procurement policy framework that was enacted in 2000. In Zimbabwe, just neighbors, they have what we call Indigenization and Economic Empowerment Act. Botswana, they have Industrial Development Act. So as you can see, neighboring countries within the region and even beyond, even in COMESA, Kenya also have differential treatment regulations. Competition law, the question is, does this tamper with competition? The answer is no. Competition encourages healthy competition. It advocates for principles that will ensure that there should be no market monopolies, there should not be corrosive tendencies and restrictive tendencies. So based on these principles, the action that we are attempting to take may be justified. So these two instruments are almost similar. It's only that they are separated because the maker of the law in one instrument is different from the other. For the 64 regulation, the intention is to provide modalities on how the indigenous black Malawian can be encouraged, can be uplifted, so that we should all be involved in the public procurement. It is not saying that the non-indigenous black Malawians will not participate. No, no, no. They are saying you participate, but can we leave this quota? Maybe can we leave this 60% for IBMs? The rest will be able to compete. So you need to register as a supplier with the ministry responsible for trade, and you'll be issued with a certificate as an IBM. If you're a company, then there is need for you to have 80% owned by indigenous black Malawian. Of course, other countries, they have put it at 51%, like South Africa, Canada, Zimbabwe, they have put it at 51%. So it's up to us to determine whether this is too ambitious or maybe it's a good starting point. The modalities are that when the PTE, procurement and procuring and disposing entity, is making its procurement planning, which you already do, the additional obligation is to ensure that in the plan which you are submitting to BBTA, you should include 60% of the value of your procurement. In that particular financial year, you should indicate that you are allocating to indigenous black Malawian. It's an old obligation, but it will just be modified. This entails that you need to change the way how you do things. In the award of contract, if you are doing it on the request for quotation, it should be restricted to IBMs. And if you are doing it in a competitive way, 20% preference margin should be applied for NCP if you are dealing with the indigenous black Malayan. Where it's a restricted tender, you also need to comply with preferences and reservations which the Director General may set from time to time. So I'll skip about the registration environment because I talked about it. Who is eligible? It should be indigenous, it should be black, it should be Malayan. And how do you prove this? It's through maybe national IDs for you to be Malayan. You need a national ID to be black. It's about black-skinned person of African ancestry that should be regarded as such. Remember, we are not introducing anything new. It's what section, the scope of what section 44 of the Act I say. Because others were saying, why don't you say citizen? But if you say citizen, we are going to conflict with what the Act says. The Act was passed by Parliament. These being regulations, they are supposed to dance to the tune which the Act has set. So maybe if we amend the Act first, then the regulations will follow suit. The license that may be, the certificate that may be issued is revocable and it can be suspended where there is a mischief. What are the duties of PBTA? The same duties of monitoring and maintaining a database as well as capacity building, considering that this is a new field. The supplier, the question is, should the fact that one is an IBM make him less compliant with the law? The answer is no. What we want is build capacity. We can't build capacity by lowering the standards. So they'll still be required to comply with all contractual obligations as the law. And all the principles of procurement, such as value for money, need for equality, transparency, will still be adhered to. So what are the duties of PTE? A PTE is supposed to comply with the set preferences and reservations, obligations, and submit reports on how they have complied, because you are required to submit quarterly reports. So when you are submitting those quarterly reports, which you are already required to do, you should just add a component that should mention to what extent you are complying with IBM requirement, and to what extent you are complying, say, with MSME requirement. As we see. So there will also be offenses such as flaunting. It's already an offense, but this will be particularized in the sense that there might be instances where one would lie that this company is 80% owned by indigenous black Malayan, maybe after ordering government, just for the sake of appearing to be an indigenous black person, when actually behind the person there is someone who is different. So this will be an offense, misrepresentation, delay in compliance, or non-compliance, or unauthorized assignments. Penalties, the penalties are limited by what the Act has stipulated, which is 500,000 or 2 years. We have also administrative sanctions, such as you can be disbarred in accordance with Section 192 of the regulations on public procurement. You can also be reported to your professional body. You agree with me that though all of you are here in procurement, you're from different fields. Some are accountants, some are lawyers, some are engineers. You have your own professional bodies. So the PPTA can report you to those bodies so that it should be sanctioned accordingly when there is a breach. So that's it about the 64 regulations. The next is MSME participation order. The spirit is the same, to uplift the weaker ones in the field. It was regarded as an MSME is somehow disadvantaged in the way it should participate in the procurement. Examples were cited, like by Justice Intawe, talking about the burden on tax, for example, on MSME cannot be the same with a bigger company. Or even the delayed payments, the way it may affect an MSME will not be the same way it will affect a bigger entity. So they need an affirmative action. They need to be uplifted so that in the end they should feel motivated, as our honorable minister has emphasized on the need to motivate and give opportunities where they do. The mandate, I've not explained much. The beneficiaries are MSMEs and marginalized groups. On this one, we had to consider other groups such as women and the youth as marginalized, as well as people with disabilities, because they are in a more disadvantaged position. This defines thresholds. This is defined according to thresholds that are in the policy, because there is already a policy on micro, small, and medium enterprises. Now there is laws need to be coherent with each other. They should be able to talk to each other. We can't set a threshold that is already set somewhere. So Ministry of Industry and Trade already have a policy which has set thresholds in terms of annual turnover, in terms of number of employees, in terms of value of assets that we have. So in terms of annual turnover, the range, the continuum is from 5 million for micro, 50 for small, and 500 million for medium enterprises. So I'll not dwell on the other criteria. The modalities is the same. During your planning, you should make sure you indicate how much is allocated for MSMEs. In the bidding documents, there is an extra obligation. You should indicate applicable preferences when you are all preparing bidding documents. To say, for, let's say for women, this is the percentage. For micro, this is the preference. For small, medium, etc. So that it should be as transparent as possible, and they should make others, the users, aware. So when you're awarding the contract, you should specify the procurement of goods, services, and works are reserved for MSMEs, and grant 15% preference margin on goods and services, as well as 10% on works. There might be more than one preference as applicable to a supplier. So in that instance, which one are you going to choose? The rule is choose the one that is the most economically advantageous position to the MSME, because the spirit is to promote, not to bring down. So subcontracting, it's also allowed. We talked about the issue of partnership. I think Honorable Gantu talked about partnership, and this is also considered that an MSME may not have capacity to supply on its own. So maybe after partnering with another MSME, it can have that capacity to supply instead of losing out completely. So when there is partnership, the requirement is if you partner with an MSME, it's fine. But when you partner with a bigger company, we are saying the bigger company should be motivated to be given a 5% preference margin. But that should not just go like that. The BDE's duty is to ensure that there is a clear contract, one, which is defining the role of each. The payment terms are clear so that the weaker part should not be marginalized further. And lastly, there should be a clear plan indicating what are the knowledge transfer measures that are going to put. Because we don't want this person to just be marginalized. Later on, the person should be able to stand on his own. Okay, so there is need for knowledge transfer so that there should be progress as opposed to just being stuck at one position. We also thought about Buy strategy. So wanted to make the law coherent and be able to speak with Buy strategy. So there is a need, there is a requirement to prioritize locally produced goods. One important feature which we have introduced is set aside for certain procurements, goods and services. These are in the schedule. They are also set aside for works. They also have a separate schedule. The reason why we separated the schedules for works, because under the NCIC framework, there is already a threshold of contractors. So we didn't want to be in conflict with them, because we are dealing with the same person who we call a supplier when it comes to BBTA, but we call a contractor when it comes to NCIC, but it's just the same person. So we didn't want to bring conflicts in terms of which regime shall apply. So on set-asides, we have also prohibited competition between categories. If you are a micro, you should compete with a micro. If you are small, you should compete with a small. If you are medium, you should compete with a medium. And how do you determine this? We have set the criteria based on your annual turnover, number of employees, as well as the value of your property. The duties are similar with the PVTA. The Minister of Trade is the one to register, shall plant license, and there also be offences. The offences are going to be not different from the ones that are in the Act or the other regulations. So they'll still be applied. If it's flaunting, it's flaunting. If it's a misrepresentation, it's if it's collusion, corruption, we already have the laws in place. So lastly, there also be criminal sanctions. I think at this juncture, I should stop here. Sorry that I was closing for the reasons that I stated at the beginning. Thank you.
Thank you, Council. It's always a pleasure having you around. Before you go, probably I can invite the board chair to present your pride or our gratitude, as we always say. Mr. Amos Nyambo and the Council, please go. Yeah, so he's talked of the 60-40, just setting ground to what will be discussed in the panel discussion this afternoon, immediately after lunch. Thank you very much, Mr. Council Kelious Mlenga. A big round of applause for Kelious Mlenga. Ladies and gentlemen, allow me to say a few remarks before we close for this chapter of the morning. Allow me to say thank you very much, Justice Intaba and Honorable Vera Kantukule, Kelious Mlenga Council, for the wonderful presentations. Thank you very much, Mr. Board Chair Amos Nyambo, Madam President Alinafe Banda Malisawa, and all those that took part in the presentations this morning. A big round of applause to all MIPS members for your patience and your attentiveness. You have seen what we are discussing now. I know when we are talking of procurement issues, people that are working in the other sectors of the supply chain, like in stores, you are like, that's not my business. Why are they talking about procurement? Don't worry, next time you will be in the procurement sector, in the procurement aspect of it, and you will now realize why you needed to be here at this particular time. We will be breaking up for lunch. We'll observe time. I know we have lost some time, but we didn't lose because we have invested that time. So we'll go out for lunch for 1 hour. We'll be back in here 2